In the first major test of the VRA, South Carolina v. Katzenbach, decided in 1966, the court upheld Section 5 of the VRA as a proper exercise of power under Section 2 of the 15th Amendment under a rational basis test. The court said these provisions of the VRA were a valid remedy for past voting discrimination and that Congress was justified in finding that case-by-case litigation was inadequate to combat widespread and persistent discrimination in voting. Another provision of the VRA was tested in 1966 in Katzenbach v. Morgan. At issue in Morgan was a provision of the VRA that no person who completed 6th grade in a Puerto Rican school where instruction was in Spanish shall be denied the right to vote because of failing an English literacy requirement. In 1959, in Lassiter v. Northampton County Board of Elections, the court had held that literacy tests administered to all prospective voters did not violate equal protection. New York law included such a literacy requirement, and some registered voters in New York challenged this section of the VRA as an improper exercise of congressional power in light of Lassiter. The petitioners argued that Congress did not have authority to interpret the Constitution through legislation contrary to a holding of the Supreme Court. In his majority opinion, Justice Brennan held that Section 5 of the 14th Amendment gave Congress the same broad powers expressed in the Necessary and Proper Clause. He applied a three-part test derived from McCulloch v. Maryland. 1, whether the statute is appropriate legislation to enforce the 14th Amendment. 2, whether the legislation is plainly adapted to that end. And 3, whether the legislation is consistent with the letter and spirit of the Constitution. But under this test, Justice Brennan stated, it is not for the court to review the congressional resolution of these factors. It is enough that we are able to perceive a basis upon which Congress might resolve the conflict as it did. Here, the VRA easily passed this test. Justice Brennan's opinion includes his famous one-way ratchet footnote, footnote 10 in the original opinion and footnote 1 in the edited opinion in our casebook. In his dissent, Justice Harlan argued that Justice Brennan's opinion allowed Congress to usurp the court's role in interpreting the Constitution. If that indeed be the true reach of Section 5, Justice Harlan suggested, then I do not see why Congress should not be able as well to exercise its Section 5 discretion by enacting statutes so as in effect to dilute equal protection and due process decisions of this court. In the one-way ratchet footnote, Justice Brennan stated that Congress's power under Section 5 is limited to adopting measures to enforce the guarantees of the amendment. Section 5 grants Congress no power to restrict, abrogate, or dilute those guarantees. Not every case involving congressional action under Section 5 of the 14th Amendment, however, has resulted in such broad deference to Congress. In City of Boerne v. Flores, decided in 1997, the court considered whether Congress had the power to impose the requirements of the Religious Freedom Restoration Act, RFRA, on the states. RFRA was passed in 1993 in response to the court's decision in Employment Division, Department of Human Resources of Oregon v. Smith, a 1990 case in which the court held that neutral, generally applicable laws can be applied to religious practices even if not supported by a compelling governmental interest. Smith went against a line of earlier First Amendment precedent, holding that otherwise neutral laws that burden a religious practice must be supported by a compelling governmental interest. RFRA legislatively required a strict scrutiny test for any federal or state laws that burden religion, even if those laws are otherwise generally applicable. Writing for the court in a 6-3 opinion, Justice Kennedy qualified the holding in Katzenbach v. Morgan. According to Justice Kennedy, under the 14th Amendment, Congress can enact legislation to remedy or prevent violations of constitutional rights, but cannot alter the scope or meaning of those rights. The power to interpret the Constitution in a case or controversy, Justice Kennedy said, remains in the judiciary, and if Congress could define its own powers by altering the 14th Amendment's meaning, no longer would the Constitution be superior paramount law, unchangeable by ordinary means. The court adopted a congruence and proportionality test to assess whether a congressional enactment under Section 5 of the 14th Amendment is proper. Under this test, there must be a congruence and proportionality between the injury to be prevented or remedied and the means to that end. Lacking such a connection, legislation may become substantive rather than remedial or prophylactic in operation and effect. With City of Boerne v. Flores suggesting a tack away from Katzenbach v. Morgan, the court took up a case involving the Voting Rights Act of 1965 once again in Shelby County v. Holder in 2013. The VRA contained some federal pre-clearance requirements that applied only to some states in the South and to one county in Arizona based on racial voter suppression practices as of 1964. Some of those jurisdictions argued that things had changed between 1964 and 2013 and that the continuation of those requirements was no longer justified. Writing for a 5-4 majority, Justice Roberts agreed that the VRA's formula subjecting jurisdictions to special requirements violated Congress's powers under the Enforcement Clause of the 15th Amendment. According to Justice Roberts, the 15th Amendment is not designed to punish for the past. Its purpose is to ensure a better future. Requiring only some states to obtain pre-clearance, Justice Roberts said, violates the principle of equal state sovereignty. Justice Roberts noted that Congress could develop a different formula based on current conditions under its 15th Amendment enforcement powers, but the existing formula based on 40-year-old data could not be upheld. In a dissent, Justice Ginsburg noted that the VRA's pre-clearance regime caused the progress in the covered jurisdictions so that it made no sense to remove those effective restrictions. Further, Justice Ginsburg argued, various second-generation barriers to minority voting, including racial gerrymandering and use of a system of at-large voting rather than district-by-district voting in cities with a sizable black minority, persisted. When confronting the most constitutionally invidious form of discrimination and the most fundamental right in our democratic system, Justice Ginsburg said, Congress's power to act is at its height. Finally, Justice Ginsburg criticized the majority's use of the equal sovereignty principle, which she said applies to terms on which states are admitted to the Union and not to remedies for local evils that have subsequently appeared. As you can see, the question of congressional power to enforce civil rights becomes particularly contested as applied to the states. Recall when we covered the Commerce Clause last semester that we suggested there were stirrings of a new federalism under the Rehnquist Court, although the movement towards a new federalism never quite came to fruition. The new federalism, or at least debates about the balance of federalism after the civil rights movement, also appears in these civil rights enforcement cases. United States v. Morrison, decided in 2000, was a case we studied under the Commerce Clause involving the civil damages provision of the Violence Against Women Act. Recall Justice Rehnquist's statement in Morrison in striking down this provision of the VAWA under the Commerce Clause, that the Constitution requires a distinction between what is truly national and what is truly local. Recall also Justice Souter's comment in the dissent that, by passing legislation, Congress indicates its conclusion, whether explicitly or not, that facts support its exercise of the commerce power. The court in Morrison also considered whether Congress had authority to enact the civil enforcement provisions of the VAWA under Section 5 of the 14th Amendment. In the majority opinion, Justice Rehnquist applied the congruence and proportionality test and held that the civil remedies provision exceeded Congress's enforcement power. In particular, Justice Rehnquist stated, because the VAWA civil remedies provision is not aimed at prescribing discrimination by officials with the 14th Amendment might not itself prescribed, and is aimed only at individuals who have committed criminal acts motivated by gender bias, the statute improperly intruded into the state's police powers. In a dissent, Justice Breyer argued that there was ample evidence before Congress that many states had not enacted laws under their police powers to provide civil remedies against state institutions that failed to prevent sexual violence. As the differences between the majority and dissenting opinions suggest, one way to look at Morrison is in terms of whether Congress can step in to provide a remedy in the face of state inaction. Justice Rehnquist's opinion, consistent with his overall views about federalism, suggests that the decision whether to act in a matter relating to police powers belongs to the states, absent a specific constitutional provision requiring action. Justice Breyer's dissent suggests that the remedial provisions of the post-Civil War amendments can support congressional action precisely when the states fail to act. As the notes in the casebook suggest, after Morrison, the court has reached inconsistent results and has applied different types of scrutiny to a variety of cases testing Congress's power to enact civil rights legislation that applies to the states. Sometimes it has applied a rational basis test, Sometimes it has applied heightened scrutiny, and sometimes it has applied a balance and proportionality test, usually, with the exception of U.S. v. Georgia in 2006, a unanimous decision involving a deliberate refusal by a state prison to accommodate a prisoner with a disability in closely divided cases. The best approach to this kind of case is probably to test the statute first under rational basis scrutiny and then under a balance and proportionality test. It may well be that under the current, more conservative court, the new federalism will see a new revival, and Congress's civil rights enforcement power as applied to the states will face a stronger balance and proportionality test, but we shall see.